Thank you very much to the ABA and David for inviting me out here. Kind of like the last panel, my job here is to give the sort of 30,000-foot overview on the state of the Second Amendment because notwithstanding the excellent presentations that we had in the first panel, obviously all the data in the world doesn't matter if, for example, a court says, but what about the right? So that's why I'm going to sort of give a framework about talking about the Second Amendment, and hopefully it'll generate some good questions. So I want to leave you with four things from my discussion very briefly here. None of them, I think, are very controversial. If anything can be said not to be controversial about the Second Amendment. First, the Second Amendment after Heller and McDonald has solved the one question that had been before the court and in the sort of general public about, all right, is the right an individual right, kind of like the right to speak, or is it a collective right, a right in an institution called the militia? And in Heller and McDonald, a majority of the court said that it is an individual right. And nothing but a constitutional amendment would change that. Second, Heller and McDonald definitely limit but do not eliminate the ability of elected public officials and public policy groups or direct democracy to enact gun regulations aimed at preventing or reducing gun violence and accidents. The Second Amendment may, as Heller says, take certain policy choices, that's a quote, off the table, but they do not make gun policy and gun politics solely the domain of the federal or state judiciary. Third, there is a difference between constitutional law and constitutional politics. That is, the Constitution takes the realm out of the court's certain things and takes out of the political realm certain things and puts it in the courts, but not everything. And the blending of these two types of concepts, the constitutional politics and the constitutional law, is a source of great vexation in most of our discussions about the Second Amendment. And the fourth, it's always important to remember that the Second Amendment is a floor. It is a minimum set of rights. It is not a ceiling, as many states experiment with what we might think of as even more expansive gun rights, either through their state constitutions or through positive law of the state legislatures. So let me unpack a little bit of this a little bit. Like I said, Heller resolve the question that had been sort of percolating, at least in the courts, for many, many years, in terms of what is the right about. Most people up until about the late 20th century understood the right as being a militia-oriented right. Heller and McDonald, through a concerted effort of the National Rifle Association as well as scholarship to make it an individual right, and that saw its fruition in the Heller opinion. But it did not say, as I saw a T-shirt recently, that the only license that one needs to carry a firearm was signed in 1789. That is not what Heller says. It is not an unlimited right, and I want to quote a section of Heller directly on point, which says that we are aware of the problem of handgun violence in this country, and we take seriously the concerns raised by many of the amici who believe that prohibition of handgun ownership is a solution. The Constitution leaves the District of Columbia, that's in Heller, a variety of tools for combating the problem, including some measures regulating handguns, but the enshrinement of constitutional rights takes certain policy choices off the table. But Scalia's own opinion says nothing in the opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. And importantly, in footnote 25 of that same opinion, Heller expressly says these are examples and the list does not purport to be exhaustive. So what is on the table versus what is off the table is the set of questions that in a post-Heller world get litigated. what kind of enactments based on the good sort of public policy recommendations of the first panel are to be deferred to, and which are to be scrutinized, and which are to be rejected out of hand. Not to get too much in the weeds, but the predominant way that the lower courts so far have applied Second Amendment after Heller is what might be thought of as a category and scrutiny test, or a history and tailoring test. That is, the first part basically asks, are we even dealing with a Second Amendment issue at all? The sort of safe harbor provisions that I remarked on, that is, possession by felons or the mentally ill, have been treated in lower courts as not even raising a Second Amendment question. It simply answers itself. They are not covered by Second Amendment rights in these sort of domains. But we've basically exhausted a lot of felons who have been caught with a pistol, who tried to say I have a Second Amendment right to own this. They've all lost. Pretty much all lost. And now we get into harder questions like does waiting periods and other kinds of things implicate the Second Amendment? And in trying to answer that set of questions, the courts apply this kind of category scrutiny test. If it doesn't fall within one of these safe harbor provisions, they look to something like history. Well, is this something that historically was regulated? If it was, then the argument is that that's presumptively constitutional. If it wasn't, then we often move to some kind of scrutiny. Now, for those of you that haven't taken con law in a long time, right, you might remember that there were 3 levels of scrutiny. There was rational basis, any kind of reason you can offer, that's good enough. There's something like intermediate scrutiny, which says, is this substantially related to an important government interest or an important government objective? And then there's what's known as strict scrutiny, which is the provision narrowly tailored to fit a compelling government interest. The way the scrutiny levels used to play out, it was if it was rational basis, the state almost always won. If it was strict scrutiny, the government almost always lost. If it was intermediate scrutiny, who knows, right? I'm not sure which way it's going to go. And to be honest, probably in most cases post-Heller, that's the way it's gone down now. Most courts apply an intermediate scrutiny test to most kinds of regulations that don't fit within the safe harbor, and as a result, many, I think over 90% of regulations have been upheld. But it's worth noting that there has been some outliers. For example, recently the tiers of scrutiny, as I've discussed, have sort of broken apart in terms of what's known as a facial challenge. That is the regulation unconstitutional in all applications? Versus as applied challenges, which is it unconstitutional as to this particular person? So in 2 cases that have just come down recently, one in the 6th Circuit, one in the 3rd Circuit, having to do with either felon in possession laws or prohibitions on somebody that has been put in a mental institution involuntarily. Those provisions have been challenged on an as-applied basis. I don't know about other folks, but for me, it is unconstitutional, and in both of those cases, the court has said that the challenger has won the as-applied challenge. So I think in the future, we might see more of these sort of as-applied challenges, not challenging facially, for example, a prohibition on felons in possession, or facially a prohibition on certain types of arms, but arguments that, as for me, it's unconstitutional. What else can I say about it? The constitutional politics versus the constitutional law. I think it's important to raise this because you hear a lot in the kind of general sort of political realm, the Second Amendment thrown around as a kind of cudgel to use. You don't believe in the Second Amendment because you believe in regulations. Well, that's a non sequitur. I might believe in regulations and also believe that the Second Amendment protects certain rights. We're having a disagreement not over the Second Amendment, we're having disagreements over what the Second Amendment means. So one of the problems here is that, you know, the Second Amendment has an incredible sort of political purchase. I have heard, and you probably have heard it, people say, for example, that Starbucks, because they keep people from carrying their arms into the Starbucks, are violating somebody's Second Amendment rights. Well, all the lawyers in here knows that doesn't make any sense, right? Starbucks is not a state actor. Starbucks is not the Commonwealth of Virginia. If Starbucks wants to keep guns off its property, they typically have a right to do so. But the fact that that has such a political valence is one thing that actually acts as an impediment to actually making some good policy programs, because you run into a rights architecture that is itself not has not been resolved in terms of our political community. So where does that cash out? Well, that cashes out, of course, in the kinds of things that I wanted to say as a fourth matter, which is the Second Amendment is a floor, not a ceiling. So we're still having arguments about what does the Second Amendment actually protect. It obviously protects, from the Heller decision, the right to have a operable firearm by law-abiding citizens in the home for self-protection. That's the core holding of Heller, and much of our debates are how much beyond that is the Second Amendment protect? Does it protect, for example, having a certain type of weapon? Does it protect having weapons outside? Is there a constitutional right to carry firearms outdoors for self-protection? But as I said, it's also it's a floor. It's not a ceiling. So in the first panel, it came up, for example, that many states who have enacted pro-gun legislation will do things like say it is a Second Amendment protection to keep physicians from asking their patients whether or not they have firearms in their homes. Georgia has the so-called guns everywhere law that basically permits people to carry guns everywhere, and actually creates strange rules like it's not a reasonable suspicion to stop somebody that's in front of a building that has a firearm just because they have a firearm. They have to do something else. So what's happening in terms of these sort of pushing the outer boundaries of what we might think of as pro-gun legislation, not particularly Second Amendment legislation, but pro-gun legislation, is now it's starting to run up against other kinds of constitutional issues, some of which our law enforcement officials be familiar with. What actually constitutes now reasonable suspicion of some kind of criminal behavior going on that I can stop somebody if having a gun in front of a jewelry store late at night is not enough. What does the First Amendment right mean when you sort of push out these outer boundaries of gun rights with respect to physicians' First Amendment rights to actually ask questions of their patients? What does it mean to say, as some states have the so-called guns to work laws, to say that if you are an unwilling property owner, that you have to allow somebody into your parking garage or onto your parking lot with a gun in their car? What would happen if the same kind of law didn't have any religious exception, and it was a Quaker meeting house or a Buddhist a Buddhist temple that would have to allow people bringing firearms onto the premises? And so that's what I would say is the kind of next vanguard of issues in terms of the Second Amendment, not only in terms of the Heller decision, but more largely the relationship between gun rights and other constitutional provisions. Thank you.
This is an issue that I feel deeply and passionately about. And it is one that profoundly is impacting more and more people across Virginia and across America. It's heartbreaking to see it this way, but you really feel like more and more families are impacted by gun violence. More and more communities are being impacted. The numbers alone make that understandable. 33,000 deaths a year. Some of those are mass shootings that get national attention. Some of those are not. And so whether it is an individual or a family, or whether it is an entire community or a nation, this issue is affecting directly more and more people, and more are saying this needs to change. I'll give you one example. And in my work, I've had an opportunity to talk with individuals who have been severely wounded and injured by gun violence. I have spoken with family members who have lost loved ones. I have spoken with people who have lived in communities where there's been a mass shooting. You all probably remember a little over a year ago, back last August, there was the horrific shooting of Allison Parker and Adam Ward, two young journalists from Roanoke who were shot and killed while they were on the air on WDBJ. And a couple of days after that, I drove down to Roanoke to attend a vigil to honor their memories and honor their lives. It was in the parking lot of WDBJ. It was full. There were TV cameras everywhere. And while I was there, I saw a woman who was in great emotional pain. She looked empty. And I started talking with her, and it turned out that she had lost her granddaughter to gun violence just about a month earlier. Her name was Makisha Lipford. Her daughter, Araya Lipford, was just shy of her second birthday. And she had been shot and killed by her mother's estranged boyfriend. And it just brought a sense that sometimes we become aware of a mass shooting like at Blacksburg, more recently in Orlando or Newtown or Aurora. Unfortunately, we're beginning to know these cities by mass shootings. But it's also, for me, it was also a reminder that individuals and families are feeling this in streets and cities and communities all across Virginia and our country. And that is why I am so passionate about this issue, and that as Attorney General, I'm going to continue to use every tool that I have, including the visibility of the office, to try to find solutions, to work with whoever I can in order to make sure that whether it is a mass shooting or whether it is an Araya Lipford, that another family doesn't have to feel that kind of pain and suffering. I hope as a part of the conversation I'll have an opportunity to share with you a few things that we're doing in our office on the issue, as well as talk about maybe some of the constraints that I have encountered in my work as a policymaker, and any other issues that you have while I'm here. So thanks very much.
I'm going to talk about a very important part of most every public health campaign, which is litigation. Litigation can incentivize responsible behavior that reduces gun deaths and injuries, and it can disincentivize dangerous practices that contribute to gun violence. Another part of litigation that we do at the Brady Center is to ensure that laws allow for positive gun violence prevention measures and that we remove impediments to gun violence prevention measures. And before I go into that, it's important to understand that the law gives the gun industry a number of special privileges that no other industry in America has, and we would not tolerate with any other industry. Only guns are exempt from federal product safety oversight. Federal government can require safety devices for BB guns, for stuffed animals, for bunk beds. It cannot do so with one of the most lethal products on the market, firearms. The gun industry has special protection from common law negligence in many cases because of federal law called the Protection of Lawful Commerce in Arms Act, enacted in 2005. The gun industry can shield information from public disclosure. It's the only exemption that I know of to the Freedom of Information Act. And law enforcement is prevented from doing its job in ways that have no parallel to any other industry. ATF is prohibited from doing more than one unannounced inspection of gun dealers in a year. There's nothing like that for any other law enforcement agency, but gun dealers know that if they get through one spot inspection, they're home free for 12 months. And there's going to need to be a warrant or probable cause. So there are those restrictions that contribute to gun violence, but within that framework, there's still a lot that we can do as lawyers. And the first thing, and maybe the most important thing, I think, is we can take legal action that can reduce the supply of guns to the criminal market. The fact is that it doesn't just happen that criminals get guns. And people often say, well, we've got all these millions of guns in America, so you can just get them. No, you can't just get them. They don't grow. They're not, you can't, pick them in the field. You generally don't make them. You buy them. And the fact is, and listen to this stat closely, about 5% of gun dealers in America supply about 90% of the crime guns. 5% of the gun dealers sell about 90% of the crime guns. And at the same time, about 85% of gun dealers sell no crime guns. So we know that the overwhelming percentage of gun dealers are responsible business people, take their job very seriously and do what they can to keep guns out of the wrong hands, but you've got this 5% of what we call bad apple gun dealers. And at the Brady Center, we target those gun dealers by representing victims of gun violence in liability suits against gun dealers like that, to change the incentive, to make it no longer profitable for those dealers to supply criminals, straw purchasers, and dangerous people. Let me give you an example of a case that I had. I represented two law enforcement officers in New Jersey who were both shot by a felon, and it turned out that the felon got his gun from a trafficker who had used a straw purchaser in West Virginia. Basically, he had gone into a gun store in West Virginia with this woman. He picked out 12 guns. She did the paperwork, and he walks out of the store with the guns and sells them to criminals in New Jersey. We represented those officers. We got a court decision that the gun dealer could be liable for that, and then we ultimately got a $1 million settlement for the officers, and maybe more importantly, a number of gun dealers in that jurisdiction agreed to no longer engage in multiple sales. They agreed that they would only sell one handgun a month to reduce the risk of trafficking. And I could tell you many other cases that we have like that, representing victims in Kansas, Missouri, Indiana, New York, and elsewhere. We had another case we brought against a gun dealer in Milwaukee, Wisconsin, that was the actually the #1 seller of crime guns in America for a couple of years. Also on behalf of 2 police officers who were shot with a gun that was sold in a straw purchase, and we got a $5.7 million judgment against the dealer. So that is a very effective measure that we can do. Another thing we can do is fight laws that impede gun violence prevention measures. There's been talk about Dox v. Glocks. We actually brought that lawsuit against the law in Florida that prevents physicians from talking to patients about guns. And there was just an argument before the 11th Circuit en banc this summer. We're awaiting a decision, and hopefully the court will strike down that law. There was a ordinance in Nelson, Georgia, which required heads of households to have a gun in the home. We challenged that, and the community agreed to rescind that ordinance. And there are many other examples I could give. Maybe I will if we have more time. And in closing, let me call on particularly the lawyers here that there is a lot you can do. One thing you can do is join us. We have a national alliance called Lawyers for Safer America. If you Google Lawyers for Safer America, you can find the sign-in sheet, and you can work with us and stay informed about different sorts of litigation. And I would recommend to all of you to speak up, stay informed, stay involved, and become a part of the conversation to prevent gun violence in America. Thank you.
I want to thank Professor Miller for giving us that 37,000-foot view as far as the Second Amendment in con law. It's been about 35 years since I last attended a con law class, and so remembering things like strict scrutiny and all that sort of stuff brought me flashbacks back from law school. Anyway, I want to give you my perspective as a practitioner, a Commonwealth's attorney for the last 32 years, so far more down to the ground level. And I want to talk specifically about a specific population of those with a demonstrated and documented history of violence. And those are those folks who have been convicted of the misdemeanor crime of domestic violence. Federal law 18 U.S.C. 922 G9 makes it a federal felony for someone who's been convicted of a misdemeanor of domestic violence to possess a firearm if that prior domestic violence misdemeanor had as an element of it physical force. There is no parallel Virginia statute. And of course, it sort of boggles the mind that here we have folks with this demonstrated history of violence towards a loved one, and yet it's not a crime for them, or not a state crime at least, for them to possess a firearm. It is a federal crime, but the problem here, and the problem has always been one of federal manpower. We just don't have enough assistant U.S. attorneys to go out and do all these particular prosecutions. And what was difficult for a time became almost impossible. Back in 2010, the Fourth Circuit decided a case called United States versus White, in which they held that Virginia's domestic violence assault and battery law, being a common law assault and battery, did not fit the federal definition because common law could be both a harmful and an offensive touching, and there may very well not be that particular element of physical force as required by the federal statute. And so while there was some very narrow ways to get around that, they were very difficult to do. And unfortunately, in 2014, the U.S. Supreme Court, in a case called United States versus Castleman, said that actually that was exactly what Congress had in mind, common law assault and battery, when they passed 18 U.S.C. 922. So we're back from the impossible back to making it just difficult in order to prosecute these cases. So right now we are at this particular level, that when we're talking about those who are possessing firearms with a misdemeanor domestic violence conviction, we got two sides of the coin. First side is what we've talked about. There are a few federal prosecutors. It's just a manpower issue, and Congress keeps making new crimes, but they keep forgetting to add new prosecutors, sort of like the Virginia General Assembly does to us. The second side of the coin, and this is an interesting part of it, is because Virginia does not make it illegal for someone to possess a firearm with a domestic violence misdemeanor, there's no provision for restoration. And so for those who have a misdemeanor domestic violence, not a felony, because if you have a felony domestic violence or a felony malicious wounding or whatever it might be, you get your rights restored. But with a misdemeanor domestic violence, there is no mechanism under Virginia law for the restoration of gun rights. And so we have that sort of unusual situation. In my mind, the goal here is to get a state law passed that would make it illegal for those who have these misdemeanor domestic violence convictions to keep them from possessing a firearm. And that way enlist Virginia's approximately 800 Commonwealth attorneys, and I'm talking about our assistants as well, get us involved in these particular prosecutions. Now, it's been discussed specifically more in the earlier panel about Virginia's current political climate and how hostile it is towards this kind of an idea. Well, I want to quote someone where he said that politics is the art of the possible, the attainable, the art of the next best. That noted liberal from 150 years ago was Otto von Bismarck. Bismarck says politics is the art of the compromise. Now, I know compromise can be considered to be a dirty word, but if we're going to get a state law to make it illegal for someone to possess a firearm after having a misdemeanor domestic violence, we're going to have to compromise on this to some degree. And again, this is my opinion. I'm not advocating from any particular group. But I would submit to you that if we're going to get this particular law, we must match it with the possibility of a restoration of rights at an appropriate time. And I want to stress the word appropriate time and an appropriate situation where someone has a demonstrated, at that point in time, ability to possess a firearm. Now, unfortunately, if that's the case, this is where it gets a little tricky, because Congress, in passing that particular code, section 922, and its predecessor 921, has basically said restoration, it said that any conviction for which a person has had the civil rights restored shall not be considered under the federal law. So what are the civil rights and what are civil rights restored? And that's where it gets a little tricky, because civil rights, while there's no definitive answer, the dicta from the Supreme Court has indicated that means more than just the right to possess a firearm. It means the right to vote. It means the right to sit on a jury. It means the right to hold public office. And so there's a rather broad definition. California had a law where a misdemeanor domestic violence would just remove their ability to possess a firearm and wouldn't touch the other rights as far as rights to vote. And the Ninth Circuit struck down a restoration and said that was not appropriate in a prosecution for a 922G9 violation was appropriate because they did not take away all one's civil rights. And then the other tricky part is civil rights restored. Does that include those states where the rights have never been revoked, or does it mean only those states where the rights were revoked? That has been answered, and it means those states where the rights have been revoked. It does not include Virginia, where we've never had a history of revoking rights. So what does that mean as far as the art of compromise, using that dirty word? What that means is we've got to get those who are reluctant to come to the table to come to the table. Because it's going to be a process, and rather than just going to the General Assembly and hearing no or hearing nothing, or as I think it was Josh said, hiding under the table, under the desk, we've got to compel the other side to come to the table. And so this is just what I'm going to do. It's going to start, at least as far as I'm concerned, it's going to start with me. And in fact, I've got a meeting tomorrow with Tim Hafey's successor as the United States Attorney for the Western District. And we're going to get folks in my office who are to be designated as Special Assistant U.S. Attorneys, SASAs, to go out and prosecute these particular cases in federal court. And so basically saying, look, folks, you've been avoiding this issue because there's very few federal prosecutions. Fine. Now we're going to do some federal prosecutions. Let's come to the table and let's talk. And so We hope, again, we haven't started it yet, but we hope to have this up and running by the first of the year, and hopefully sometime here in the near future, we will get the members of the General Assembly to come to the table and have an open and frank discussion about the art of compromise. Thank you.
Thank you, Mike. Again, write your questions down and give them to Lori, but I've got some up here already. And I think that I will start with the Attorney General because I know that he's on somewhat of a tight time frame. Somebody asked, why are nearly all politicians scared of tackling this issue? And I want to actually ask you about the premise. Is that true?
Well, I'm not scared. And there are others who are not. But I get the gist of the question. And I think there are way too many officials and policymakers who are either too beholden to or intimidated by the NRA and the gun lobby. One of the reasons for that is they're very good at mobilizing their members and having them contact their legislators or policymakers, whoever. So they're very good at activating their membership to speak out against even the most, what I would consider very common sense measures to address gun violence. And in one particular instance, when I took some action to enforce a law that's been on the books in Virginia for a long time, that some of my predecessors, many of my predecessors, just either deliberately or otherwise were indifferent to the existence of that law. It was a reciprocity for concealed carry permits. When I saw that the law should be enforced, we received literally thousands and probably thousands of phone calls, emails from all over the country. And for some people, that can be very intimidating. But I also feel like we've turned a corner on this issue in a lot of ways. Just this past weekend, I was at an event. The organization was nonpartisan, but certainly made up of members of the faith community, many different faith communities, probably 1,000 people in the auditorium. And they were there because they wanted elected officials and policymakers to be accountable, to say where they stand on a small number of issues, and one of them was this one. And they are energized. I am convinced that in Virginia, as well as other states around the country, we're seeing too many people being affected by gun violence, and that's changed. So I think that accounts for a lot of it, and there is a lot that we can do. And I'll let others comment on that if they want.
Josh, if I could add,
Of course.
Josh and I have both been around this issue for a long time, 20 years or so, and I mean, in this campaign, we've seen, Hillary Clinton has run on a very progressive gun violence prevention platform. I'm not shilling for it, I'm saying it's just a fact. And on the eve of the third and last debate tonight, it's worth noting that in one of the debates, Hillary Clinton talked about gun violence prevention. Donald Trump's response was not to give the NRA line. His response was to say, I disagree with the NRA on terror gap, and I think terrorists should not be able to buy guns. Very interesting that he thought that on a national platform, he wanted to sort of go on the gun violence prevention side of the equation. In the vice presidential debate, Kaine spoke about gun violence prevention, Pence did not respond. So you have no candidate has talked the NRA line in any of the debates so far. I think that's a very significant point. It shows that there's, I think, has been a great shift and reached a tipping point on this issue.
Okay. I think that's a really strong point, John. Attorney General Herring, what is it that you talked about developing political will and now more electeds being willing to take on this issue? Is there something that the people of Virginia need to do to help demonstrate that they're ready for this? Ready for instance, background checks on all gun sales?
I think that kind of activism is really important to counterbalance the perception that some elected officials have when they begin to talk about this issue. So it's extremely helpful to counterbalance that. And there are a lot of things that we can do. Just to give you a sense of some of the things that we're doing in our office, I have reallocated resources to prosecute gun crimes. We've gone from one prosecution a year to over 100 so far this year. And most of these gun crimes are involve also violent crime, narcotics trafficking, gang violence. And so I've reallocated resources to make sure that we're doing everything we can to support both the Commonwealth's attorneys and the U.S. attorneys' offices in prosecuting these crimes. There's no substitute for stronger laws, but in the absence of that, I'm going to look for other ways. So I've had some meetings, and our staff have as well, with attorneys general in Maryland and D.C. about gun trafficking and Virginia being a source state. But we're looking at identifying which of the gun shows are producing most of the guns used in gun crimes, and then having a larger presence there. And we've got experience in how to make that presence effective. Another area that we're looking at is in internet gun sales. I think that should be a real concern. There are some of the auction websites that do require a federal firearms licensee to do a background check, but not all. And attorneys general have come together to address all kinds of issues that come up with the internet. We work to get Craigslist to crack down on human trafficking. And so we're looking at ways that we can get gun auction websites to do this voluntarily, to warn buyers and sellers what the criminal and civil liabilities are for shipping firearms and so forth. So I think there's some things that we can do, but those are voluntary steps. Same with best practices for gun dealers. We can work with those gun dealers that we find have the highest percentage of guns used in gun crimes. And that may not be that they themselves committed any crime. It may be that they have transferred it and it was a lawful sale, but then finds its way into the hands of a criminal or someone who is dangerous. But what we can do is go to them and say, we would like to work with you in a cooperative way to try to minimize the number of guns that are getting into the wrong hands. And we can't make them do that, but we can show them some of the data. Many of the dealers are responsible. So we want to try to find whatever ways we can. But all of those voluntary measures, in my view, while they're helpful, they are no substitute for stronger laws like universal background checks. We talked about, is there something else that people can do? That's something that 90% of the people, probably more than 80% of gun owners believe should be done. We need to try to get that happen and to expand in Virginia the domestic violence restraining orders to be broadened from what some of the other states have in terms of gun violence restraining orders. Measures like that would be a huge help.
Okay. Mike?
I ought to be amazed, but I'm not, given the stats like the Attorney General just cited as far as the polling data and how Americans respond to sensible gun control legislation, and yet we don't pass any of these particular laws. And so when I'm addressing civic groups, I say, look, you want just the fact that the NRA yells louder and more vociferously than you does not make them right. It just makes them loud. So vote. Be sure to get out the vote. I know that sounds sort of, okay, yeah, that's easy to say, hard to do. Well, another part of it is maybe a lot of our members of the General Assembly aren't representing the population, and certainly the data suggests that they are not. And so redistricting reform is another way of talking about this. And on any number of levels beyond just gun control, is having folks in the General Assembly who represent the views of those of us who vote. And so those are some of the other suggestions that I would have.
Before I go away from this particular line of questions, let me ask you, for people who spend a lot of time in the General Assembly, how important is it for citizens to actually show up?
It's always good to see people from home when you're down here in Richmond. One of my political mentors, when I first got involved in politics, was a county supervisor. And he told me that I'm going to, as a county supervisor, I'll be in a room, there'll be 100 people in the room. They all may be saying I should do a certain, vote a certain way or take a certain action. And you may feel like, oh, wow, everybody in the room thinks I should do this. Obviously, there's overwhelming support for it. And he reminded me, though, when the meeting's over and you walk out the county administration building, and I represented the Leesburg district, the county seat, you're going to see that you are in a district with 20,000 people. And just, it's important to hear that. And so when we get, in my case, thousands and thousands and thousands of emails for enforcing the law that was on the books, it's important to remember all of those other people who I know are there. And if we want to try to get new laws passed that really need to be done, sometimes it does take people to come to counterbalance the other side's activism, because they're there, and it's really nice to hear from other folks at home who have a different, we want to hear from everybody, but if legislators only hear from one side and they don't hear the views of others, there may be a belief, a false belief, an incorrect belief that, well, everybody feels that way. Well, that's why it's important for other people's views to be heard as well. So those of us who believe that we need universal background checks, we need to take some reasonable steps, should be more active in contacting legislators to let them know how you feel.
All right. So Daryl and John, I'm putting you on notice that I'm coming to you after this question. Okay. So I got a question here, I think probably for Attorney General, for Mike, asking, we've seen terrible tragedies in the Commonwealth with law enforcement being killed in the line of duty. Do our weak laws play into the hands of those who would do harm to our officers, and what should we do about it?
Okay, I thought you were going to John.
No, that's one more question for you guys, and then
Okay.
over to the end here.
Well, it's obviously illegal to kill a police officer. It's illegal to shoot a police officer. It's already illegal to do all this sort of stuff. So I'm not sure, I guess we're talking about the proliferation of firearms.
Or in the DV situation, where oftentimes it might be legal.
And it's certainly in the DV situation. To me, there's no question in the DV situation that there's an awful lot that has to be done and has to be done now. Now, I will say this, is we did actually have a relatively decent victory in the last General Assembly session, where it doesn't sound like much, but there was a change in the domestic violence protection order law that added the word possess. Previous to this amendment, it was illegal for someone who was subject to a final family violence protective order to purchase or transport a firearm, but it was not illegal for them to possess a firearm, even subject to a family violence protective order. And so that word was added, and it was made a felony as well. So it certainly put a lot of teeth into the protective order law. There's a lot more we can do along those particular lines, though. One of the stats that we talked about in implementing this particular new law was the fact that in 2015 there were approximately a little over 36,000 emergency protective orders, family violence protective orders that were issued by magistrates. Less than 6,000 of those became final protective orders. So along the way, we're losing 5/6 of the people who seek an emergency protective order. And there's a number of reasons for that. But some of the reason, and one of the reasons that we're trying to work with in Lynchburg, is it's a complicated procedure if you don't have a legal background. Victims of domestic violence, they're going before a court. It's a scary place to begin with. It's a scary time for them. They're in a very tumultuous time. And now we expect them to sit around all day and go through a court proceeding. And so we're working very closely, and we're actually going to have people on the ground in the juvenile and domestic relations court to help people work their way through the domestic violence protective order situation. So, getting back to the law enforcement aspect of it, obviously we need to do something dramatic about the proliferation of firearms. But that is a very big haul to come in many years to come.
Okay.
I would just add that guns getting into the wrong hands, those who are criminals or dangerously mentally ill, puts us all at greater risk.
I think that's well established in the data. All right, let's switch back to some of the Second Amendment and legal issues here. I got a question basically saying, did the questioner hear this right, that most Second Amendment challenges have been, in fact, thrown out or not been effective? The challenges themselves have been dismissed?
Yes. I mean, there have been hundreds, maybe over 1,000 now, challenges to gun laws claiming that the laws are unconstitutional, and almost all of them have been rejected. That said, from our perspective, we've sort of got to bat 1,000, because if you lose one case, a very important law can get struck down, and there have been, a small handful that have gone the other way. Professor Miller talked about some, but the short answer is yes, and for the most part, courts have refused to expand the Second Amendment much beyond the relatively narrow holding in the Heller Court.
Bring the mic close to you, Turn it off.
Okay. And it kind of depends on how you count, right? So, every good criminal defense attorney was saying, felon in possession, Second Amendment rights, right? If you, count all those, there's lots of those cases and they all lose. So it kind of depends on if you count by type of case or absolute number of cases, just as a statistical matter. But it is correct that it's been the outliers have been the cases that have thrown out a regulation, and obviously those are the ones that tend to be high profile. For example, Moore versus Madigan in the Seventh Circuit, Judge Posner said that there is a right to carry an arm off of one's property, and other courts have not so held, or have not held there's a right to carry a concealed weapon off of one's property. They haven't really gone to the basic question about whether there's a right to transport the firearm. The other thing I just want to mention very briefly about the gun violence is the thing that came up in the first panel, which is the sort of technological issue, right? So any kind of good policy program has to, I think, allay the significant fear among gun owners that somehow their rights are being taken away. there is at least some potential to sort of thread the needle when we talk about the kind of smart gun technology that would only enable the person that is lawfully permitted to have the gun to keep it, because it's not subtracting from their safety, and it prevents a gun that's stolen from being used in a crime later on. Now you have to get past the paranoid style of American politics, which is that any kind of regulation is just one step on the slippery slope to nationwide confiscation, which I think most people had hoped that Heller would kind of sort of cure that fever, but as we've seen in the recent election campaign, it hasn't. That's still a talking point of the NRA that the Second Amendment is in peril, and the NRA makes a lot of money from stoking that fear. But I think there's at least some opportunity for some kind of reasonable compromise that allays the fear of reasonable fears of people that otherwise might possess firearms.
Hey, just real brief, just on the previous question about law enforcement.
Yeah.
And I've represented about a dozen or so law enforcement officers or their families over the years that have all been shot because of bad apparatus. And so that's a big part of the problem too. The same dealers that supply the criminal gun market, of course, law enforcement, sadly, they put their lives on the line and they bear the brunt of that too many times. And so that's a big part of the problem, is cracking down on those responsible actors.
Agreed. Darryl, let me see if I can formulate this question in an intelligible format. You mentioned that the Heller plaintiffs were trying to get the Second Amendment to be recognized sort of in the same constitutional style as the First Amendment. Mm-hmm. We're also seeing the rise of people open carrying in many states around the country. And I've heard them say directly, this is actually speech and now it's protected by the First Amendment. Is carrying a gun in public speech?
Not so far. It's funny you should say that, because I'm working on a project about this sort of expressive value of the Second Amendment, because that's what academics get to do. But no, right now to say I've got a right to, this is just like a sign, right? My gun. That is not. It's behavior. It's like burning a draft card or something like that. You can regulate things because it's dangerous to burn stuff. So it's an activity. I think that the question is especially pertinent now, right? Because we have a political season in which sort of speech, people getting together, and gun rights all seem to converge in one place. And so I think it's important to sort of think through those kind of implications about what kind of spaces would we be really concerned about the presence of firearms anyway, like the polling booths, for example. But as far as I can tell, there's not been any cases said you have a sort of First Amendment protection to speak silently with your gun. That's not just an ordinary rule about ordinary legislation like open carry.
And there's a fundamental right to live, okay? And that is more significant than any other right. I actually have a law review article coming out called The Right Not to Be Shot that goes into this. And the point is that every constitutional right, when it butts up against the right to live, the right to live is predominant, okay? If you're engaging in snake handling in church, there have been cases like this, and you say you've got a First Amendment right to do that, courts have said, no, you don't, because it can endanger other people. And the same thing with the First Amendment, and certainly with the Second Amendment, where you have a right to lethal arms, when it butts up against the right to live, in my view, the right to live overcomes that. And so, I think the Second Amendment law is just developing now, and hopefully there will be more recognition of that sort of basic principle.
I've never articulated it as well as you just did, but I'm glad the article's coming out because it's sort of an inchoate thought that we've had, and I'm glad you're putting it down, and I'm very interested in looking at that article. So you're talking about, in what you just mentioned, competing rights, Second Amendment versus the right to live. What about in the physician gag rule, the competing rights between the Second Amendment and and physicians' First Amendment rights to speech and things like that? Is there a competing rights analysis in that gag rule?
Well, that's kind of the argument in our view, as representing the physicians challenging the law. There is not really much of a conflict because you have a Second Amendment right to have a gun in the home. We're not taking that away. Doctors aren't taking that away when they ask you if you have a gun in order to give you health and safety and medical advice. And the fact is that this Florida law that's being challenged would allow doctors to ask about your sexual history, about whether you have Drano or things like that, and how do you store it. But if you ask about, do you have a gun in the home, you could lose your medical license. That's what the law did. It authorized the revocation of medical licenses. So, yes, it was a coin a phrase, a trumped up.
And I think that's the point I was trying to make in terms of there's the constitutional law, and then there's the constitutional politics, and this is a piece of constitutional politics, right? Because I think for somebody who would advocate such a gag rule, they would say this is about the Second Amendment, but it's not really. It's really about the state wanting to expand on sort of gun rights through its own legislation. The only true constitutional issue in that case, unless I guess it would be a VA hospital or something, would be the First Amendment right of information, right? Is this a reasonable regulation of the practice of medicine, or is this an infringement on the free speech rights of a medical community to basically practice their profession?
And in that case, the American Academy of Pediatrics recommended protocol was to have doctors ask those questions. So, this is equivalent to a law that says you can't ask people if they smoke to prevent people from telling them that smoking can be dangerous to them. Really would, a law like this would set precedent for that sort of thing.
So, okay. On the balancing the rights issue, Professor Miller, I was really interested in the property rights issue you brought up, because in Virginia, people can bring guns onto government parking lots and things like that, and there's been bills introduced to make it into private parking lots, and it seems to me that implicates a core property right. How do you balance that with the Second Amendment rights? Do you need to balance it?
Well, okay, so there's two ways that I can imagine thinking about it. One, I wrote a piece about sort of corporate constitutional rights, and my colleague Joseph Locher wrote a piece called "The Right Not to Keep and Bear Arms." And so, one way of thinking of it is just ordinary property. And so, to what extent can positive legislation like Virginia or whatever, Florida, say we are regulating a business, and just like they can't turn away people on the basis of religion or race, this is regulating a business. So you have to allow guns onto the parking lot in the same way that you have to, make sure that it's cleared, or they're, or post signs of certain kinds on the premises. So that's one way of looking at it. The other interesting way of looking at it, I think, is either the kind of First Amendment versus the sort of gun rights view. That is, the example I gave here, a Quaker community, and you believe in pacifism, and you say having a gun on the premises actually undermines who I am as a religious community. That's a pretty powerful argument. There's some exploration out there about, for example, the Religious Freedom Restoration Act, state versions of this that says that's impinging on my religious freedom to have this kind of law. You don't have a compelling reason to force the gun onto my premises. The other way of thinking of it's not really a First Amendment argument. It's actually the Second Amendment argument, that essentially one argument would be either I have a right not to bear arms and having the gun on the property violates my rights, or I have the right to be the only person armed here, right? So it's, it's only my gun that's allowed here. And I can say to you, the only person that's allowed to sort of police this area is my designated, security detail or my designated security person, and I'm going to arm them the way I want. And the state is trying to basically inflict some kind of hazard on me that impinges my sort of safety rationale that's at the backstop of the Second Amendment. So that's the way that I would think through that particular set of problems.
Okay, so I know that the Attorney General needs to leave. Do you want to make any final remarks or maybe a minute on what your next priorities are, or do you just need to leave right now?
Yeah, I think I need to leave now,
Okay.
but I do want to thank you all for inviting me, and keep up the good work.
Okay, thank you so much for doing this. So we have time for just a few more questions. I did get some questions about restoration and how right now restoration of rights for firearm rights is how we do that in Virginia, and how might that work under a DV? What kind of evidence would you want to see before you restore rights in a domestic violence situation?
Well, of course, everything's in a state of flux now because of what happened this past summer with the restoration of all rights and the automatic restoration. And one of the associated things that just comes with that is once the civil rights have been restored, the fact that they can then petition the circuit court to have their firearms rights restored. We do have a bifurcated system in Virginia as far as restoration for felons. And again, as I said in my earlier comments, there is no such parallel provision for domestic violence misdemeanors. There's no provision at all for restoration there. But with felons, there is the restoration of all your other civil rights, and then you petition the circuit court. And at that point, the circuit court makes a determination whether or not there's good cause to restore the firearms rights. The question is a good one. It is not one that I have a fully fulminated answer to, just because there are so many things that have to happen first. And the first thing that has to happen is Congress has to change 18 U.S.C. 921 as far as that particular requirement for the restoration of civil rights. And what does that include? Rights not revoked? Does that include for those folks in years past, will they never get their rights revoked or rights restored? I've had some dialogue. I happen to be represented in Congress by the chair of House Judiciary, Bob Goodlatte. So I've had some conversation with his staff, but it's gone no further than that. We think that the General Assembly, oftentimes nothing happens. Well, Congress, really nothing happens, and certainly not in an election year. So, whether they reach back out after the first of the year, we'll have to wait and see. But I mean, there's nothing at this point in time that is. I don't have a concrete proposal as far as that, except for to stress the word that it's going to be, restored only upon appropriate circumstances.
Okay. So I think I'll ask the last question here. I think it plays on this congressional inaction and maybe some changes that hopefully will come someday. But John, you mentioned the idea that gun manufacturers are insulated from liability like no other manufacturers. How did that? I think that's called PLACA, and it's a law, Protection of Law for Lawful Commerce Arms Act. And John, how did that come about? And I think I don't want to start. What are the prospects for starting to chip away at those provisions?
Well, first of all, I mean, we've chipped away at it some just in the courts by litigating cases and developed a now body of law that clarifies and some exceptions in the law allow for some liabilities. All these cases that I've talked about, we've been able to pursue despite PLACA. That said, it's an awful law. It gives protection to manufacturers, in some cases dealers, for negligence liability that no other industry has. I mean, it came about basically because gun litigation was very successful. When the NRA had George W. Bush in the White House, they said their number one priority was to get this immunity bill passed. And they eventually got it passed in 2005. It actually failed in 2004 when the Senate voted for a gun show loophole amendment and an assault weapon ban amendment. And when that happened, the NRA withdrew its support of the bill because they couldn't tolerate those two provisions. And after the 2004 election, the elections don't matter. They definitely do matter, because after the 2004 election was reintroduced and President Bush signed in 2005. So that's how it came about. There is interest in Congress to repeal PLACA or to narrow it. Adam Schiff from California introduced legislation. Senator Murphy Blumenthal in Connecticut did as well, and a number of others have. So we'll have to see. I mean, Hillary Clinton actually has made the repeal of PLACA a major priority for her. It was a major issue in the Democratic primary because Bernie Sanders supported PLACA and she opposed it. We'll see what happens if there's increased momentum to repeal it. And what's important to know is that no one is suggesting that a company, manufacturer, dealer should be liable for a crime simply because they sold or made a gun that was used in crime. That isn't what any of our cases were about, and you don't need a law to prevent that sort of liability. Judges throw out cases like that; they do all the time. The only thing that PLACA does, or the worst aspect of PLACA, is to prevent gun companies that are negligent from being held liable.
All right, so I'm going to bring back up Dr. Fox and David Clark for closing comments. And I want to thank the panelists for a terrific discussion today, and thank the audience for great and thoughtful questions, and for the civil and civic dialogue that we had today. There's a lot to think about as we approach the elections. I think this gave us a lot more to think about. And I appreciate everybody being here and the terrific questions. Let's give a round of applause for you.
Thank you, Josh, and thanks to all our speakers. It is, and I know we have our representative of the American Academy of Pediatrics who is here, and I appreciate you. We appreciate the attendance, the interest. We had legislators, law enforcement officers, physicians, public health people, people of all walks and interests. And I appreciate that. I think it's making a difference to have the physicians and law enforcement out front on this issue now. I think people is getting some attention. And we had our law enforcement representatives. They were seated at the back. They were reminding us that they have our backs. But we appreciate all the participation. And I think we did invite some people on the other side of this issue to be on the program. We did not have any acceptance. But thanks again. We can make a difference, as our political leaders here have told us they like to hear from us, and I think we can make a difference. Thank you very much.